Judges in the dock, defenders of democracy, or vandals in ermine? What is the judiciary's role in a modern democracy? I have been studying the judiciary for over a decade, empirically and historically. I've used computational models to explore judicial decision making, and I have used history to explore the changing relationship and balance of power between judges and administrative government. The judiciary is an ancient and trusted institution. It occupies a significant place within our constitutional imagination, but it is also increasingly a contested institution, with judges depicted as willfully positioning themselves in opposition to the government of the day. Few things illustrate this as clearly as Brexit. In September 2019, the Prime Minister, against the will of the majority of MPs, advised the Queen to prorogue Parliament. The Supreme Court held that the advice was unlawful. The political response was swift. The decision was branded a constitutional coup. Judges were described as enemies of the people and were accused of using judicial review to conduct politics by other means. The judiciary's defenders were outraged, but the accusation was not new. In 1981, when the House of Lords ruled that Ken Livingstone's policy of subsidizing public transport was unlawful, the GLC's transport chairman described the judges as vandals in ermine. In the early years of the century, David Blunkett, after losing yet another case, angrily declared that he was fed up with judges overruling political decisions. It is time, he said, for judges to learn their place. Nor is this confined to the past 20 years. Consider this excerpt from an internal government memorandum. In recent years, the weight of prejudice against the state in the minds of many judges has been such as seriously to affect the administration of justice. And the memorandum goes on to say that this trend has made it difficult for the state to obtain justice from the judges. That memorandum, which I discovered in the National Archives, was written in 1929. Now, it is this claim and that criticism that launched me on this line of research. It is easy to dismiss criticism of the judiciary, but it is important to put that criticism in context. In cases like the prorogation decision, the judiciary was pronouncing on matters that were the subject of political debate and contestation, and it was intervening against policies and strategies adopted by persons in high office. Is it appropriate for the judiciary to post themselves in such matters? And can it fairly be said that doing so takes them beyond the bounds of faithfully applying the law into the domain of politics? It is obvious why we need to ask this question, but it is challenging to answer it in a systematic and dispassionate way, unbiased by our personal views on the substance of the contested matters. It was to resolve this problem that my colleagues and I turned to computational statistics, devising an empirical model that we used to estimate or analyze judicial involvement. The technique we used is called ideal point estimation. And although the mathematics and computational techniques underpinning it are complex, the idea behind the model itself can be explained quite simply. Ideal point models are used by political scientists, typically studying how liberal or conservative individual senators on the US Senate are. By comparing all votes of all senators on all issues throughout their entire career, it is possible to put them on a single scale and computationally estimate how they rank relative to each other and how the positions shift over time. We adapted this model to take it outside the liberal conservative American spectrum, and we applied it to decisions of the UK's highest court. We looked at the decisions of every judge on every case involving a public body from the 1980s to the present day. And here is a graphical representation of the most interesting result. Every line on this graph represents a judge. The lines appear and disappear as judges are appointed and retire. As you can see, there are clear differences among judges. The lines show the existence of distinctive positions or judicial philosophies associated with specific individual judges. And as you see towards the end of the graph, there is a clear trend reaching a peak in the past decade, of an increase in the separation between judges' positions. This does not, however, vindicate the skeptics. The existence of different positions among judges does not mean that they are deciding cases based on their ideological preference or that they are abusing judicial office to conduct politics by other means. Nor does it show that they are doing anything but apply the law faithfully. What it shows is something rather more interesting. If we go back to the data and look at the cases which contribute to these positions, what they actually reflect is that what is entailed in faithfully applying the law has changed dramatically in such a way that the differences of the sort this graph discloses are not only inevitable, but are in fact necessary for the law to be faithfully applied. Let me explain. Over the past 8 decades, the nature of law and the lawmaking process have changed as administrative government has assumed a broader set of functions. When we think of law, we tend to think of Parliament and statutes passed by Parliament. In point of fact, however, much law is now made by ministers through statutory instruments, regulations, rules, orders, and so on. Statute enables ministers to make these, but the scope of the things they cover is exceptionally wide. And as the body of legislation made by ministers has grown, the opportunities for Parliament to examine, scrutinize, and control it have reduced. How many MPs do you think were able to read and debate and consider all 1,500 pages of the EU UK trade agreement in the few days between its conclusion and the passage of the legislation to give it effect? This is not an unusual state of affairs. This means that cases now come to court on the basis purely of administrative practices that have received very limited scrutiny and consideration from outside the administration. These trends pose a new range of questions for the court, which makes the task of applying the law faithfully a much more complex and a much less deterministic endeavor. Let me give you an example drawn from one of the cases in our dataset. The statute establishing employment tribunals gives ministers the power to fix fees that claimants pay to bring actions. Are there limits to the amount of fees ministers can set? What if the fees are set at a high level and made unrecoverable? A measure whose necessary effect will be to bar a considerable body of claims from coming to the tribunal. In giving a minister the power to set fees, did Parliament intend to let those fees be set in a way that restricted the claims that could be brought? How should judges decide cases of the sort? How should they decide whether ministers acted within the constraints the law placed on them? What should they follow? The words of the statute? Some sort of parliamentary intention? Broader general principles, purposes, and priorities? Some mixture of these? As this example highlights, the changing nature of lawmaking poses new questions for the courts to which there is no obvious right answer when it comes to faithfully applying the law. There is no single approach that will consistently produce faithful outcomes. None is more obvious or faithful than the others, and none is necessarily better than the others. It is hard to see why faithfulness to the words of a statute is superior to faithfulness to the principles and goals which the legal system tends to prioritize. Through a combination of historical and empirical work, my collaborators and I have traced some of the approaches the courts use to deal with the challenges presented by the rise of the administrative state. The differences to which this model points represent differences in relation to how judges go about the task of faithfully applying the law. The balance between the role of the words of the statute, general principles of the common law, and other broader overarching priorities that are embedded in the law. Different judges tend to have predispositions to different techniques, and it is those differences that this model captures. Putting the model together with the cases in the dataset also reveals a second trend. The rise of the administrative state has given executive government the power to do much good. But it has also given it the power to do much harm, and the cases in the dataset provide several examples where private persons have been woefully and grievously injured by government action. The political decision to enact the Human Rights Act and to confer its powers on the courts represents a political response to this problem. The struggle to embed a culture of giving adequate priority to the interests of private persons in the everyday operation of administrative government, rather than subordinating those interests to the pursuit of administrative goals. It's against this background that we must view the growing role of the judiciary in matters that are also the subject of political contestation. The expansion of the judicial role is, in effect, a manifestation of the struggle to reconceptualize the rule of law for an era of administrative government and executive lawmaking. These results have two important implications for ongoing debates about the judiciary. The first relates to diversity. Our work suggests that when seen in historical perspective, differences among judges are productive and beneficial. It is impossible for a single judge to consistently make the right calls and for a single tool to always yield the right answers. It is through dialogue and debate and through discussions between judges on the collegial court that the law's tools develop, that settled approaches emerge. And the law is therefore better for this sort of process. It, in turn, benefits from intellectual and methodological diversity amongst the judges, of a type that comes from a diversity of backgrounds and a diversity of routes to the bench. Contrast this with the US, where until the recent appointment of Justice Barrett, every single judge on the Supreme Court had attended either Harvard or Yale. The second implication relates to political criticism of the judiciary, much of which is rooted in a misplaced nostalgia for a simpler time when judges rarely intervened in administrative affairs. This nostalgia, however, ignores the link between the rise of the administrative state and the changing role of the judiciary, which means that to the past there can be no returning. The correct question is not how judicial review should be reformed, but how the process of institutional dialogue between the judiciary and the administration should be reformed. Not just the judiciary's powers, which politicians are quick to hop on, but the broader issue of the quality of the administrative government's processes for understanding and engaging with the requirements the law imposes on it, which governments rarely, if ever, consider. This institutional dialogue is a key theme in the ongoing research, not just of myself, but also of a range of my colleagues in the law school, and it is of profound importance to our system of democratic government. As the regulations to deal with COVID have shown, the balance between the interests of the individual and those of the government, between order and liberty, is a difficult one to strike. And it is only through dialogue between law and administrative government that we can get the balance right. For all that the judiciary can be legitimately criticized for some of its decisions, To the extent that dialogue and that balance is their mission, they are indeed democracy's defenders. Thank you.